One of the most important things that we do with startup companies is provide them with something called the Founders Agreement, or it can also be called the Initial Shareholders Agreement. And it basically determines three or four things. First of all, it will determine how the company is organized, who sits on the board, and typically that's the major founders, the major shareholders from among the founders initially, and can be investors later on. It will also set out what happens to shares. Typically, founders like to control who are members of the ownership group. You don't want one founder turning around and selling his shares to someone else, unless it's for tax planning purposes to members of the family and things like that, and as long as the founder maintains control of them. But our shareholders agreements will typically have provisions that say that other founders will have a right of first refusal against a founder's shares if the founder wants to sell them. It'll say that if one founder finds a buyer for their shares, and if none of the other shareholders want to buy those shares, then the other shareholders get to what's called tag along. In other words, everyone gets to participate in a sale of their shares, pro rata their holdings of shares, so that no one founder or shareholder can take advantage of selling their shares without the others participating. And then there's an important provision that's called the drag along. The drag along is a provision that says if a certain required percentage of the shares, holders of the shares decide they want to sell, let's say 3/4 decide they want to sell the company, then the remaining shareholders must participate. And that's a means of ensuring that you don't have opportunistic shareholders kind of holding up a sale of the company going forward. So that's the second category of things that it deals with. That's kind of the sale and dealings with shares. The third is, what happens when people leave the company, or what happens when small shareholders start to acquire shares in the company. Part of the problem with having lots of small shareholders, or having shareholders who are no longer, let's say, employees or directly involved with the company on a day-to-day basis, is that it can hold up things like financings. They can either be uncooperative or they can be hard to find. So what we tend to suggest in our shareholder documents is if someone has shares in the company, if they're below a certain ownership percentage, or if they are a former employee who's left the company, then the CEO or the secretary of the company, or someone who is continuously with the company by title, not by name, would have the ability to vote those shares on behalf of that person. The person still has the economic value and still has the economic, growth value of those shares, and they still own the shares. It's just that they don't vote the shares. They don't sign for them either. So there's a power of attorney involved in that as well, so that the company can actually execute documents and can vote the shares on behalf of that shareholder, so they don't prove to be either troublesome to find or problematic in their actions at a later date. The fourth kind of major component that we usually include in the shareholders agreement or the founders agreement is the reverse vesting provisions. And those can be in a separate agreement sometimes, and maybe we'll speak about them separately, but that's basically the provisions that say that a founder or another initial shareholder may get shares on day one, but some of those shares can be repurchased by the corporation for no value if that person leaves the company before a prescribed period of time has passed. It's kind of like a stock option, but in reverse.